All rise. Oh yay, oh yay, oh yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning, everyone, and welcome. We're pleased to have you with us today. We have 4 cases on the morning docket, and we will call them in the order in which they appear. 3 of the cases, each side has 15 minutes to argue. One of the cases, by motion, we've granted each side an additional 5 minutes. But in each case, the appellant will have the right to reserve up to 5 minutes for rebuttal. So when you come to the podium after you've introduced yourself, please let us know how much time you would like to reserve, and the clock will be programmed accordingly. As you know, the Court of Appeals of Tennessee is one court, and we are very honored to have with us today Judge John McClarty, whose home is in Chattanooga, and he's technically elected from the Eastern Division of the Court of Appeals of Tennessee, but we're all one, and we're thrilled that he's sitting with us today. Judge Bennett and I will have the pleasure earlier and later this year to sit with him and his colleagues in Knoxville, and we all get to go to Jackson as well, but we're pleased to have Judge McClarty with us. Are there any announcements? Hearing none, please call the first case.
Araceli, Cordova et al. Versus Attorney Robert J. Martin.
Good morning.
Good morning, Your Honor. May it please the Court, Chief Justice, Justices, my name is Dave Rich, and I rise today on behalf of the Cordova family. I would respectfully like to reserve 2 minutes for rebuttal.
2 minutes, certainly.
Your Honor, there are 3 principal issues which the Cordova family advocates today as to why the lower court should be overturned and the finding of the dismissal of the Cordova family's claim for breach or filing beyond the statute of limitations for their malicious prosecution claims should be overturned. The 3 points are, number 1, no full and final favorable determination was made before January 13th, 2020. Number 2, the Cheatham County Circuit Court's application of the case of Christian versus Lapidus was in error, and that case is easily distinguished from the facts of the present case. And number 3, dismissal of the Cordova family's claims would damage the public interest and violate the statutory policy of the statute of limitations as passed by the Tennessee legislature. To provide the court with some relevant background facts, first, the claim of the Cordova family was filed on December 23rd, 2020. The lawsuit alleges malicious prosecution by Attorney Robert Martin of an unethical lien interest against the Cordova family's tort recovery. Both Rule 1.5c, the fact that he prosecuted a lien against the family with no written contract, and it was a contingency fee, as well as Rule 1.5e, that he was unethically sharing a fee with another lawyer outside of his law practice, and that was not in writing or agreed to by his client. I will note to the court that the deposition of Attorney Martin was taken before the circuit court dismissed the case, and in that deposition he admitted to both of those ethical infractions. On May 13th, 2019, an order denying Martin's motion to alter or amend was entered by the Cheatham County Circuit Court. And on December 31st, 2019, a motion to enlarge time was filed by Attorney Martin with this court, perpetuating his prosecution of the unethical lien interest. Of note, in the filings made by Attorney Martin, the pleadings note comes now appellees estate of Gary Hodges, and Robert Martin to move this court to enter an order providing the appellees additional time to file an appellee's brief in this civil action. Specifically, the pleadings before this court note that Mr. Martin had an open lien claim against the family and continued to prosecute it through January 13th. On January 6th of 2020, this court issued an order granting Mr. Martin's motion for more time to prosecute his lien claim. This court found in that order, upon the motion of the estate of Gary J. Hodges and Robert J. Martin, the time for filing the brief of the estate in Mr. Martin is extended through January 13th, 2020. Understanding that order, the Cordova family reasonably understood that the lien claim of Mr. Martin remained open and available for prosecution. Ultimately, Mr. Martin did not file a brief before this court and abandoned his appeal. So that is the relevant facts. Now, first point is no full and final determination of the claim of Mr. Martin's lien claims were made until January 13th, 2020. The factual record establishes that Attorney Martin's prosecution of the claims did not conclude until that date. Before a malicious prosecution claim is ripe for filing, quote, the prior action must be finally terminated in favor of the plaintiff. And that's quoting Lewis v. Allen at 698 Southwest 2nd, 58. There is no doubt that Mr. Martin's unethical lien claim was open and prosecuted through January 13th of 2020. The Cordova family rightfully understood Martin's lien claim was not terminated until that date, and accordingly, the Cordova family timely filed their lawsuit within 1 year of January 13th, 2020, on December 23rd, 2020, later that year. The second point is that the lower court applied the case principally in dismissing the Cordova family's malicious prosecution claims, relying upon the case of Christian v. Lapidus, found at 883 Southwestern 2nd, 71. In Christian, a conservatorship filed a RICO complaint against certain parties, including the Christian plaintiffs, and I'll refer to them as the Christians, in 1986. 2 years later, in 1988, the plaintiffs dismissed, that being the conservatorship, they dismissed their claims against the Christian defendants, removing them from the lawsuit, all allegations against them from the lawsuit, as well as the caption of the case. However, no final order officially dismissing the Christians from the case was ever filed. The conservatorship ultimately lost the case, and then following, in March of 1989, the Christian plaintiffs sought and received an order reaffirming the voluntary dismissal that occurred back in 1988. On April 4th, 1990, over 2 years after they were voluntarily dismissed by the conservatorship, the Christian plaintiffs filed a malicious prosecution claim against the conservatorship. This case is easily distinguished from the present facts of our case. The Tennessee Supreme Court noted that the Christians were not named in the caption of the lawsuit, and no allegations were made against them in the body of the complaint. This differs from our present case, where Mr. Martin was still prosecuting his lien claim as a named party officially recognized in the pleadings that were filed by his attorney, as well as within his attorney's own affidavit that supported the motion. Second, the order of dismissal sought by the Christians was unnecessary, as they had been dismissed from the case for more than 2 years. The Tennessee Supreme Court, quoting the opinion, stated, quote, we have previously noted that the effect of the amended complaint was to remove plaintiffs from the lawsuit. Therefore, at the time plaintiffs procured the order of dismissal, there was no suit pending against them to be dismissed. Although one would customarily seek a formal order of dismissal under these circumstances, delay in doing so does not postpone the running of the statute of limitations. That's different from the case that's before the court today. The Christians sought an order of dismissal for the purpose of demarking a date that they could then file the malicious prosecution. That was why they sought to have the official order of dismissal against the conservatorship. In the present case, Attorney Martin filed pleadings perpetuating the prosecution of his unethical lien claims. Lastly, the Tennessee Supreme Court recognized that in 1988, when the Christians were dismissed from the case, they received formal notice that they were no longer that claims were no longer pending against them. Attorney Martin, in this case, continued to prosecute the unethical lien claims through January 13, 2020, by the filing of his own pleadings and requests for this court to leave his lien claims open. The final point is that dismissal of the Cordova family's claims in this case would damage the public interest and violate the statutory statute of limitations policy enumerated by the Tennessee legislature. The allegations against Attorney Martin are that he willfully prosecuted an unethical lien claim against the Cordova family for more than 6 years. Such a case should be resolved on the merits. Tennessee law favors the resolution of disputes on their merits, and I'm citing Foster versus St. Joseph Hospital, found at 158 Southwestern 3rd 418. The date of the statute of limitations should be easily identifiable and not a murky calculation for the plaintiffs, and not subject to, quote, reasonable disagreement, as was noted by the lower court. If Attorney Martin is successful in dismissing this matter, it would be a roadmap to encourage tortfeasors, especially sophisticated tortfeasors like attorneys, like Mr. Martin, to give every indication a malicious claim, in this case a lien claim, is open, so that injured victims will understand the malicious claims have not yet been fully and favorably resolved. This would drastically limit, or as set forth in the current case, nearly eliminate a victim's available time to seek redress. Alternatively, this would cause confusion amongst malicious prosecution plaintiffs involved in ongoing litigation, with prospective defendant tortfeasors motivating them to prematurely file their claims before full and final termination of the lower court proceedings, so as to not violate the statute of limitations, leading to an influx of premature cases and Rule 12 dismissals, which, by the way, would potentially avail the plaintiff of attorney's fees with a Rule 12 dismissal.
Okay, so the lower court ruled against Mr. Martin on the lien, right?
Mr. Martin, yes, and Mr. Martin abandoned the claim.
And that was on October 26, 2018. Then he filed an appeal. I just want to make sure I got this in my head right.
Certainly, Your Honor.
Then he filed an appeal. And then he abandoned that appeal?
No, Your Honor, respectfully. On October 26, 2018, the lower court
adopted the special master's findings.
Yes, and adopted the special master's findings. Then on November 1st of 2018, the Cordova family filed a notice of appeal.
Okay.
And then on December 20th, 2018, Mr. Martin filed a motion to amend the final order of the lower court. That was
resolved May 13th.
May 13th of 2019, okay. Yes, Your Honor. And then thereafter, the Cordova family filed their notice of appeal. Our brief was then filed on October 25th of 2019, and then the following appeal, followed on October 25th, 2019. We filed our brief. The Cordova family filed its brief. And then on May 19th, 2020, the Court of Appeals issued a decision in the lower court case. So that is a little confusing. I'm trying to...
What is the date then? The January 13, 2020 date is when you say he abandoned...
Yes, Your Honor, because there's two separate cases. So there's the lower tort case, and then as that case was proceeding, the claim that Mr. Martin had remained open, because in the end of December of 2019, he files a motion before this court seeking additional time to file his brief and respond. And as this court noted in the decision of the other case, it refuted the argument that by not filing a notice of appeal, there is no availability of an appellee to also counter appeal. This court found in the in the opinion on the tort case that quote, Rule 3H of the Tennessee Rules of Appellate Procedure clearly provides, consistent with Rule 13A, cross appeals and separate appeals are not required. Consequently, upon filing of a single notice of appeal in a civil case, issues may be brought up for review and relief pursuant to the rules by any party.
That's correct.
The point that is ultimately there is that this claim was still open. The Cordova family reasonably understood that these lien claims that Mr. Martin had were still being prosecuted and were available for prosecution.
Had already abandoned it?
No, Your Honor, not until the 13th had passed. This court granted Mr. Martin leave until the 13th to pursue the appeal.
January the 13th.
Or excuse me, January the 13th. I apologize, there are a lot of dates.
Okay.
January 13th, 2020. It gave him until that date to pursue his appeal, which he then abandoned by not filing any
So
brief.
the final order on the lien is actually the trial court's order dated May 13, 2019.
That would be the order denying Mr. Martin's motion to alter or amend the judgment.
So that's the last order of any court about the lien, other than the appeals dismissed.
There was that was denied, and then we then filed our notice of appeal along with a brief, and then Mr. Martin provided before this court that he still sought to pursue his appeal and filed the brief and sought that time.
I understand, but if we were looking for the last order on the substance of this case about the lien, that's the May 13th, 2019 order, right?
I respectfully, Your Honor, according to the Cordova family, this pleading before this court was a substantive pleading, but in terms of the actual lower court's decision finally stating there is no more, that we're adopting the special master, we're not going to amend or alter that did occur in May of 2019.
Okay, so the last order on the lien is May 13th. You're trying to extend the time, arguing he kept it alive by appealing. I understand that.
Certainly.
I get that.
Understood.
But I'm just trying to, the last order is May 13th, 2019.
From the lower court, yes, Your Honor.
Okay.
All right.
Thank you.
Mr. Rich. We'll hear from you on rebuttal. Mr. Olson.
Good morning.
Good morning, sir.
Just briefly, it's rare that you have something that has the same sort of circumstances and the same considerations that have been undertaken, and the Court of Appeals having ruled on an issue previously. And respectfully, I think that's exactly what we have in this case. And to just give an outline of what took place in this case, Gary Hodges was hired in a personal injury case. He asked Rob Martin to help him. Rob Martin did that, but he didn't sign a contract. So that's the egregious, horrible professional responsibility violation. It hasn't been found that by the board, but that doesn't matter. What happened in this case was Hodges was fired and Rich's firm was hired. They proceeded to a settlement. There had been a settlement offer before Mr. Hodges was discharged, but that gave rise to a dispute over attorney's fees. And in the first case, what I call Civil Action 1, there was a determination by a special master as to how attorney's fees should be divided. Mr. Rich and his firm did not like that decision and appealed. The decision that we're talking about that I've made reference to in our brief was October 26, 2018. And what happened then was Judge Wallace adopted the special master's findings. That ruled in favor of Mr. Hodges, and it terminated any opportunity that Mr. Martin had to proceed on with a claim. That was a final judgment, what we consider a final judgment under the rules of civil procedure with regards to Martin. We did file a motion to amend that finding, which was denied on May the 13th, 2019. That was it. Thereafter, Martin did not file an appeal. Martin was out. He did not avail himself of a Rule 3, Tennessee Rules of Appellate Procedure appeal. The reason that becomes interesting is, and I'll have to page forward, I'm going to just truncate what I'm going to talk about here, was rarely do we have appellants now who have addressed this issue previously and this court having addressed this decision or this question before, and I'll bring to your attention what I'm talking about. In the brief of the appellant filed by Mr. Rich, the statement is made, "From the outset, it's important to note that Martin did not appeal the ruling of the trial court denying his claimed attorney's claim. Accordingly, Martin's attorney lien claim has been given final judgment by the court and is waived for the purpose of appeal." Well, the following brief discusses Martin's lien claim in conjunction with the attorney's fee awarded to Hodges. That is the subject of the present appeal. It is only discussed and referenced to the extent it relates to the Cordova family's efforts to reverse the trial court's award of a fee to Hodges in error. Boil that down, Martin's out. Now, the reason that that's important is that is something that was written by Mr. Rich, filed with this court, is, in my opinion, a admission, to give it lack of a better discussion. I don't know if you can have an admission before the Court of Appeals, but I would argue that you do. That is an admission that Martin's claim at that time is extinguished. The Court of Appeals entered a judgment.
Doesn't he go on to say that Mr. Martin asked for additional time in the Court of Appeals to file a brief?
He does, but that really doesn't have anything to do with the application of Rule 3.
Mr. Martin thinks it does.
Mr.
Rich thinks it does.
Mr. Rich does, but this court didn't. This court didn't. And what the court then addressed at page 9 of that decision, the trial court adopted the recommendation and denied Martin's claim of attorney's fees, and Mr. Martin did not appeal the denial of his claim. Thus, our analysis is limited to Mr. Hodges' claim to recover his attorney's fees. Whether Mr. Martin is entitled to recover a share of the attorney's fees awarded to the Hodges estate is not before this court. So, respectfully, again, looking at the Court of Appeals decision that was entered May 19, the Court of Appeals, this court, adopted and said, yeah, Martin's claim isn't before us. And that is respectfully just in total conjunction with what I consider to be the application of Rule 3. Martin was no longer in the case when Judge Wallace was the individual then. When Judge Wallace entered his order of October 26, 2018, that was 799 days before the filing of this complaint against Mr. Martin. The order denying...
Is that the date we use, October 26, 2018, or is it May 13, 2019, or is it...
I don't think it matters. I think any date 366 days before is it.
You'll take anything then.
Yeah, exactly.
Yeah, okay, I get it. Go ahead.
Yeah. But the point is, the final order, we believe the final order, which was something that could be considered, was the October 26, 2028 date. A motion to amend was filed, and an order denying that claim was entered on May the 13th, 2019. Then the record comes to this court. The May the 13th, 2019 date, as I've referenced in the brief, was 590 days before this court, before the appeal. So that's it. So I think very clearly it's time barred. And again, I go back to the specific things that were said in my estimation, which were important by the appellant's attorney in this case in that brief that was before the court. Hey, Martin's out. And the reason that's important is either Rule 3 applies or Rule 3 doesn't apply. And either your claim is dismissed. It is not somebody who, Martin wasn't awarded $1. He wasn't still in the case. Martin was told, you're out. Your case is dismissed. Martin did not file an appeal, specifically did not file an appeal. There was no reason to file an appeal, probably based upon the facts in this case. Plus, Hodges had his continuing claim. He was out. The case was over. The time for filing either began October or the May date. And I think the May date is a fine date. I think that's an appropriate date to look at and consider. There are reasons why I think you can argue that it's not, primarily because the motion to amend was filed late.
Well, the trial court had not entered a final appealable judgment until May 13, 2019. Isn't that correct?
Probably so.
Okay.
Probably so. Although you can, as I say, I think you can argue the October order was entered. The motion to amend was filed more than 30 days after that. But again, I go back to it and I say it doesn't matter. 590 days or whatever it is, 799 days, whatever it is, it is. And the Christian case that counsel discussed, and respectfully we disagree with his, interpretation, it's directly on point. When you've got the final order, when it's over with, when it's done, you've got to start thinking about appealing. And again, I respectfully, I understand, they want to bring this claim, they want to try and bring pressure to bear on Mr. Martin, they want to bring pressure to bear on this case. I get it. This isn't about professional stuff. This is about good old-fashioned grubby money. That's what this is about, just like every good case. And what this comes down to is they waited too long to do it. And if they had done it right after something had happened, after one of these orders had been entered, we'd be defending the case. But statutes of limitations are considered carefully. Statutes of limitations, respectfully, he talks about public policy. The termination of a case and the ability of a litigant to think that they're done is an important application of the statute of limitations. That's a part of the public policy of statutes of limitations. So respectfully, I don't think that there's anything special about this case. There's nothing special about the facts of it. The fact that Mr. Martin is a lawyer doesn't take this away from being about anything other than money. We're not verifying some rarity principle.
The purpose of this appeal is not about money, it's about the application of the statute of limitations.
Sure it is. But I submit every good lawsuit's about money.
The consequence is money.
It is, yeah, every bit of it. And I agree with you. I agree 100%. But this case is respectfully properly concluded by Judge Wolf on the order that he entered. There's really, I don't know how they run from the admissions that were made in the brief in civil case number 1. This previous court recognized in that decision in court 1 that Martin's out. Martin doesn't have a claim. If that doesn't put you on notice, I don't know what would. And I think that's the whole point. And I've got some time left, but unless the court has any questions, I think I'm concluded. Thank you all very much.
Hearing none, thank you, Mr. Olson. Thank you, Mr. Olson. We'll now hear rebuttal from Mr. Rich.
Yes, Your Honor. Respectfully, I would say, again, the matters are not before the court, but there are serious allegations against Mr. Martin and his wrongdoing and what he did to the Cordova family that ultimately led to the 6 years pursuing this lien interest. But I would state that the court should look at the lower court's decision and identify the fact that the court itself found that there's reasonable disagreement. That was the phrase that the lower court used about the statute of limitations, and that shouldn't be the case. I can say as the Cordova family's attorney, I circled that date of January 13th on my calendar, understanding that at that point there was a year left before the statute of limitations would expire in this claim. And the Cordova family reasonably would think that. Because again, Mr. Martin, after filing, he was a litigant on the pleadings, petitioning this court for additional time. Had he filed, the way the court should interpret this is, could Mr. Martin on January 12th have filed a cross appeal against the Cordova family saying, I am entitled to this money. I can claim this money. And he clearly could. And the application of Rule 3 by this court states that upon the filing of a single notice of appeal in a civil case, issues may be brought up for review and relief pursuant to the rules by any party. But at this point, Mr. Martin fairly was petitioning this court. The Lapidus case and the Christian case, was that there was no allegation against the conservatorship, or the conservatorship had no further allegations against the Christian defendants that had been dismissed. In this case, it's the complete opposite. The Cordova family had no notice that these claims had expired. Mr. Martin is still a petitioning litigant with an attorney asking more time from this court to perpetuate and prosecute his claims. And I just go back to the critical point here, and that is the no final determination. That's the critical juncture for a malicious prosecution claim. There has to be a full and final termination of the claim. And in this case, there was no full and final termination of the claim until January 13th of 2020. When this lawsuit was filed later that year on December 23rd, 2020, it was timely filed. And I would just offer to this court that the circuit courts of Cheatham County in that judicial district, it takes time to get before that court. They only hear motions once every 3 months. So the reason why the motion to alter or amend is filed in October of 2018 and then is not even heard and an order isn't found until the following May of 2019 is basically par for the course. That's normal. And in this case, the notice of appeal that followed and the months that followed for the extension of time that was requested by Mr. Martin is also normal. So the idea of these long dates and whatnot, the 700 days that counsel's referring to, are just wrong. Because again, the conclusion of Mr. Martin's claims were when he abandoned it. And so the Cordova family respectfully requests that this court overturn the lower court's judgment and allow this case to proceed on the merits.
All right.
Thank you, Your Honor.
Mr. Rich and Mr. Olson, for your arguments. We will take this matter under advisement.